Good morning, everybody. Welcome. My name is Marty Mascari. I work with the North Central Texas Area Agency on Aging. And we're blessed today to have three people here from Haiman+Hogue. Sheila Williamson, who has helped me put this whole series on, which I appreciate your help greatly, Sheila. Jeff Crouch and Rhonda Downing, and they're going to talk today about VA benefits. So first of all, I'm going to turn it over to Sheila and let Sheila tell you a little bit about the CEUs for today. And if you could advance the slide to the next slide, that would be great.
Well, good morning. We're glad to have all of you with us today. At Haiman+Hogue, our primary core value is education. So we do offer continuing education classes for nurses, and that is RNs and LVNs, by the way, LPCs, licensed social workers, and assisted living facility managers, which we have very few of that attend these, and I don't understand that because certainly they could get credit for this as well. What you do, you're going to get a follow-up email after this, and it will have two things in here. It will have a sign-in sheet, and it will have an eval. If you will send those back to me, then I will send you your certificate immediately. So we're so glad to have you, but we just do have to have those two forms completed, and I know you're used to that anyway with CEUs. This does count as a 1-hour CEU. And like I say, it's good for all of those categories. And, you know, we have some therapists every once in a while that like occupational therapists or physical therapists. I'm not certain that it will count, but they attend, and I will certainly send you one for a social worker and you can submit it yourself. So, anyway, once again, we're glad to have you. And, Jeff Crouch is he is bio. He is an attorney with Haiman+Hogue. He has about 20 years of experience, so he's got plenty of experience to answer any question that you might have. Rhonda Downing, his paralegal, has 18 years of experience, so she's got plenty of experience. So between the two of them, there's nothing probably that they cannot answer. So, but we do, one of the conflict of interest that Marty is showing, we do want to explain that we do this for a living. So Haiman+Hogue, this is not to sell you on Haiman+Hogue at all. This is strictly educational. So, and then they will be answering any question that you have. And like Marty said, please use the Q&A format or the chat. And you won't see me after this, but I will be monitoring those. And then at the end, we will take questions. Okay? Thank you.
Can you hear me okay? Okay, good. Well, good morning, everybody. This is Jeff Crouch. Welcome to our webinar this morning. Thank you, Marty, for hosting, as always. You guys do a fantastic job, and we're always honored to be a part of these things with you guys. I want to spend our time this morning talking about veterans benefits and how you and your clients and their family members can utilize veterans pension benefits to help pay for long-term care. So let's dive right in. So let's start with talking about what long-term care what we're really talking about. What we're talking about are services, either medical or non-medical, for people who have chronic illness or disability. Long-term care needs can be provided through a number of different mechanisms or processes. One is home health care, so you can have people coming into the home. Many of you on this presentation may be well familiar with that concept. We can provide that care through the long-term care through assisted living facilities. And of course, skilled nursing home facilities are a big player in this as well. The reason why we're talking about VA benefits is because we can use those potentially to pay for all types of care. Because of the way in which the VA pays out these benefits, they're paid directly to the veteran or the surviving spouse. So that money can be used in a variety of different environments, including home health care. So it really provides a lot of good flexibility for families when they're looking for ways to pay for care. Well, why are we talking about this? Well, we're talking about this because there's an increased need for long-term care. The life expectancy continues to increase. In 1950, it was 68. Now it's 78. And if you reach 75 years old, your life expectancy is projected to be approximately 86 years old. It depends on whether you're a guy or a gal, because those numbers vary. But on average, that's what we're talking about. And it may sound crazy, excuse me, but every day until 2030, we will have 10,000 of our baby boomer generation turn 65. So we continue to gray and age. Right now, we have over 56 million people that are over 65. By 2050, that number is going to jump to almost 87 million. Over 21% of our population will be over 65 by that time. And at least 70% of our seniors at some point in their lifetime are going to require long-term care. So there is definitely a great need for it. And this is, I won't spend a lot of time on this, it's just give you some of the figures. This will show you how drastically costs have increased over the last 15 years, going from $65,000 in the mid-2000s to over $100,000 currently. And it's supposed to keep going up and up each year. Where does the money come from to pay for long-term care? We're obviously going to be talking about VA benefits, but I wanted to give you some sense of the various places that it can come from. Other private basically is long-term care insurance. So if your clients or your family is lucky enough to have a policy like that, that's a good thing because it can provide very good benefits. I won't spend a lot of time talking about some of these topics, but basically to tell you that if you have a long-term care policy, familiarize yourself with it in detail as the situation arises where you need to tap into it, because there's lots of different questions. I've highlighted some here. When you evaluate your policy, ask these questions and see if you can get answers, because it will help guide you in what kind of benefit that policy will provide. So for example, what types of care are covered? What do you need to qualify? How much are you going to get a day? Is there a cap on it? Is it subject to inflation? How long are the benefits going to be paid? All of those kinds of things are topics that you would want to try to get your arms around to see exactly how that benefit is going to help. You'll see from the slide that 22% of our seniors are private paying for their long-term care, and the rest of them are getting some sort of government assistance. Medicare provides a little bit of assistance, but it's short-term. The VA obviously provides assistance. That's why we're talking today. And we have other webinars. We've had them in the past. I'm sure we'll have them in the future where we'll go through the details of Medicaid, because as you can see, a great number of the seniors are paying for their long-term care with Medicaid, but that's a topic for another day. Just real quickly, Medicare is not a long-term solution. It provides 20 days of coverage. After that, you're going to pay a copay unless you have a supplement policy. And then after the 100 days, Medicare drops out. Medicaid is another long-term solution. It provides for care after day 100 or after Medicare runs out, if it's shorter than that. It's administered in Texas by HHSC, and there's lots of different programs for whether you're in a facility, whether you're in a community. Keep in mind it is means tested, meaning that you have to qualify financially for that. So veterans benefits is another really helpful government assistance options. There's a couple of different kinds of pension benefits. We're going to talk a little bit about the service-connected benefit. We're going to talk a lot about the non-service connected benefit, which is also called improved pension, by the way. And then we're going to talk about special monthly compensation, which is an additional amount that can be paid if you're in a homebound scenario or if you need aid and attendance level care. And we'll talk about what that means here in a minute. So let's get into it. When we're trying to qualify for veterans benefits, what are we looking at? Well, let's give you a brief overview on pension benefits. What are we talking about? I mentioned it before, we're going to talk about service-connected and non-service connected. I'm going to spend a little bit of time on service-connected because they are sometimes not as common as a non-service connected pension benefit. But basically, the service-connected pension is a pension that's payable to veterans or surviving spouses of veterans who have suffered an injury during their service that disabled them or made an existing disability worse. It's kind of like workers' compensation in the sense that they give you a disability rating based on what your disability is, and it can be a wide variety of things. It could be physical disability, it could be mental disability, it could be hearing loss, it could be any number of things that, as long as there is a connection to that injury and the service, you can potentially get service-connected benefits. The important thing to remember about service-connected benefits is, although, and in some reason, because it has a service connection, in other words, you have to have been disabled or had one made worse as a result of the injury, there is no means test to it. So for those veterans or surviving spouses of veterans who have been injured during their service, it can be a wonderful benefit because it isn't based on the income or the assets of the veteran. It's based strictly on, were you injured and are you disabled, and if so, how much? There's a table that they use to determine how much compensation you get based on your disability. So for example, if you're 50% disabled, you get X amount. And it's not connected to your income or your assets. So it can be a very good benefit to pursue if the circumstances warrant it. The other type of pension benefit that we're going to spend a lot more time talking about today is non-service connected pension. It goes by a couple of different names as well: veterans pension or improved pension. It's basically financial assistance to help a veteran or a surviving spouse supplement their income. There is no connection necessary between medical or disability condition and the service. So if you were never injured during your service, or if you're a surviving spouse of a veteran that was never injured during their service, then you can qualify for this non-service connected pension. But an important distinction between the two here is that it is needs-based and means-tested. So it does depend on income and assets for eligibility purposes. We'll talk in more detail about that in a moment. I wanted to give you a visual reference of the various kinds of non-service connected pension that's available. So you see this triangle here. At the bottom of the triangle, this is what we call the base pension. This base pension applies if your service is where it needs to be. We'll talk about that. If you are disabled, we'll talk about that as well. And if your financial resources are where they need to be. Now, if you are homebound, there can be an additional add-on to the special, to the monthly pension benefit, special monthly compensation for homebound individuals, people that are substantially confined to the immediate premises. And then the top of the pyramid, the top of the heap, so to speak, from a benefit standpoint, is this aid and attendance allowance. And we'll talk about this more, but it's basically an allowance in addition to the base pension for folks that require assistance with activities of daily living, 2 or more of those. Or if you are blind or in a nursing home or bedridden, you can qualify for this aid and attendance allowance. And that's really what we try to shoot for when we are working with veterans and their families in these cases, because that is the richest benefit. And that is illustrated by this chart, which sets out the various different types of pension that's available. So your base pension, your housebound allowance, your aid and attendance allowance. And then you'll see on the left-hand column the status. If you're a veteran with no dependents, you get a certain amount. You get a certain amount more if you're a veteran with a spouse or a dependent child. Or if you're a surviving spouse, you get a certain amount as well. And you can see that in each of those status categories, there is an amount that applies based on whether it's a base pension, housebound, or aid and attendance level. And you can see that the aid and attendance level benefit for a veteran with a surviving spouse is the richest benefit. If we can qualify the veteran for that, we're going to get almost $2,300 a month of tax-free income coming into the veteran's checking account each and every month, as long as they remain qualified. Now note that these are the maximum allowable pension rates. So this is as much or as good as it gets. As we'll see in a moment, there could be deductions from that amount based on the particular circumstances, but these are the maximum amounts that are available. So when we start talking about eligibility for these benefits, these non-service connected pension benefits, we're talking about really three categories. We're talking about the service, we're talking about the particular disability or medical condition, and we're talking about the financial piece, the means test, if you will. Let's talk about service first. In order to be qualified for this particular benefit, you obviously have to be either a veteran or the surviving spouse of a veteran. If you are a surviving spouse, you must have been living with them as husband and wife at the time of their death, and you can't have been remarried unless you remarry another qualifying veteran. So it's for surviving spouses, it's that marriage connection that maintains the benefit. If you get divorced, obviously when the veteran is alive, but even after the veteran has died, if you were not married at the time of the death, then you lose those benefits. And if you get remarried after death, then you're going to lose that benefit, at least with that veteran. There has to have been an honorable discharge. Actually, the statute says other than dishonorable discharge, but that's kind of confusing, so we just say honorable discharge. If it's something less than that, they still may qualify, but we have to look at it a little more closely. They have to have served 90 days of active duty service. At least one of those days has to be during a wartime period, which we'll show you those on the next slide. Remember that it's active duty, so reserve status unfortunately doesn't count unless the reserve unit was activated by presidential order, and that has happened from time to time in Korea and in Vietnam. There were some reserve units that were activated by presidential order, and so in those limited circumstances, an amount of reserve service can count towards that 90 days. These are the service periods. So if the veteran's service falls within any of these time periods, then from a service standpoint, they are going to be inside what we call the donut hole. They're going to be in the middle of that service period, and they're going to qualify. So we still see, we do still see some claims with World War II vets. Obviously, those are declining over time, but Korea, Vietnam, and the Gulf War service period is actually still technically ongoing. There's not been a presidential order that has limited that at this point. So the disability piece of this, the second qualification criteria, you basically have to be considered disabled for the basic pension. Now, that's a little bit of a misnomer because the way the VA defines disability, it's anyone who's 65 or over. So according to the VA, if you're 66 years old and perfectly fine otherwise, you're still considered disabled for purposes of this pension. If you are under 65 and you are permanently internally disabled, you can still qualify for this pension. If you're a patient in a nursing home, if you're on SSDI or SSI, the VA considers you disabled for purposes of this pension, even if you are under 65. Housebound allowance, you can get this additional housebound, the middle of the pyramid, if you will. If you have one disability rating of 100%, or if you have two or more totaling 60%, or if you can't leave the house, then you're considered housebound and can get additional compensation. And then finally, the richest benefit, the aid in attendance. I mentioned you have to be blind or nearly blind, bedridden, a patient in a nursing home, or the most common is anyone who needs help, well, I should say a veteran or a surviving spouse that needs help with two or more activities of daily living. Those being bathing, feeding, dressing, toileting, transferring, moving around within the home or the living area. All of those things are ADLs. And if the veteran or the spouse needs help with two or more of those, then they can qualify for this aid and attendance level benefit. There are some things that people need help with that don't count for this aid and attendance qualification. If you have a veteran who, for example, is having someone provide them assistance with shopping and food prep and taking care of the household, getting them places, helping them with their medications, those in and of themselves are not going to elevate you into this aid and attendance level benefit because they are not considered ADLs, activities of daily living. They're considered IADLs, or instrumental activities of daily living. I'm not sure I'm not sure where they come up with the terminology. It's a bit confusing, but just know that if it is mission critical for you to be able to live your life, bathing, feeding, dressing, all of those kinds of things, then those are the kinds of ADLs that can qualify. So let's talk about the big one, which is the means testing. This is the one where we really spend most of our time helping veterans. The disability piece, it kind of is what it is, and the doctors will certify that. We have some input and influence on that. We work with doctors in these kinds of cases to make sure that the form that they need to fill out to make the determinations to elevate you to aid in attendance is done correctly, and that we're including everything that the VA needs to consider in that. But the means testing is where we typically spend the bulk of our time in consulting with veterans and their families on eligibility issues. And what I mean when I say the means testing is they look at your net worth when they're performing this means test. And what is net worth? It's defined as 1 year of annual income, and it's a little bit of a different annual income. We'll talk about that in a second, plus the value of your assets. The net worth for a veteran is limited to $130,773. It's a veteran or the surviving spouse. If you have a married veteran, both spouses' assets count. So the total household asset value, if you have a married case, is what goes towards the 130. If you have a surviving spouse, that surviving spouse can have up to $130,000 of assets. There are increases for cost of living. Those are done annually. It's kind of like a consumer price index kind of thing. When they increase your Social Security by a certain percentage, the percentage that they increase the VA benefit is roughly the same. And that changes in December of every year. The net worth is calculated at the date that you file your claim. So when you file the application for benefits, that's the date at which the VA is going to test net worth. So I'll back up real quick. So we said that net worth is 1 year of annual income plus the value of your assets. So we first need to look at what do we mean when we say annual income. So the VA focuses on something a little bit different than what you would expect as just general income. They calculate income for VA purposes, or countable income for VA purposes. That's called IVAP. The VA is big on acronyms, so you'll see a lot of acronyms as we go forward this morning, but IVAP is a big one. Income for VA purposes. What is that? Well, it's all income for a household, less authorized deductions. Couple of tips here or notes. Income from SSI and welfare benefits are not included in this income calculation, but everything else is. And what they do is they take your gross income from all of these sources except SSI and welfare, and then they allow you to subtract from that authorized deductions. Countable income, IVAP, cannot exceed the maximum annual pension rate. So if you'll remember a couple of slides ago, there's that chart that shows the maximum annual benefit. So as you get close, as your income gets close to that maximum annual benefit, you start to zero out your eligibility for this benefit. So the way the math works is when we calculate your IVAP, your income for VA purposes, if that number is below zero, then you're going to get the maximum rate. So $22.69 if you're a married veteran on aid and attendance. If your income for VA purposes is more than zero but less than the maximum pension rate, then you're going to get the maximum pension rate less the IVAP number. So basically a dollar for dollar reduction for every dollar that your income is, the income for VA purposes is above zero, it's going to be a dollar less that you get from the maximum pension that you would be entitled to. And at the other end of the spectrum, if your income for VA purposes is more than the maximum annual pension rate, then the claimant is not going to be entitled to the benefit. So it basically, as I said, zeroes out. The greater your income as compared to the maximum rate, the less of the pension benefit is going to be payable. So authorized deductions offset gross income. The biggest authorized deduction is what we call unreimbursed medical expenses, or UMEs. Well, what are UMEs? Let's talk about that. These are obviously reductions in countable income, and they're defined as expenses that are medically necessary to improve a disabled individual's function, or that basically slow your decline. So if there's something that you need help with that helps prevent your decline health-wise, then that can be considered an unreimbursed medical expense. They have to be recurring. In other words, it can't be a one-off thing. There are circumstances that I won't go into now because it's a little bit detailed, but there are circumstances where you can get a one-off knee replacement or hip replacement or something like that covered. But most often what we're talking about is recurring medical expenses, doctor visits, prescriptions, medical supplies, those kinds of things. And one other thing that I'll note about unreimbursed medical expenses is obviously if you get a reimbursement for an expense through insurance, for example, then that is not considered an unreimbursed expense. That's a reimbursed expense and does not constitute a reduction in countable income. So the question sometimes comes up, what about long-term care insurance payments? How are those treated? Well, depending on the caseworker that you get, sometimes they evaluate those as income, or sometimes they evaluate those as expense that's reimbursed and therefore not deducted. Either way, the same result occurs. If you're getting long-term care insurance payments, your benefit is going to be lower, all other things being equal, if that results in your income for VA purposes being above zero. Here's some examples of some things that we commonly see as unreimbursed medical expenses. And the first one is probably the biggest and can be the most significant, and that's the cost of skilled nursing care and assisted living care. If you are in a skilled nursing home, that is the easiest situation of classifying unreimbursed medical expenses. It's a given. What you're paying in the fee to the skilled nursing facility, $6,000, $7,000, $8,000 a month, whatever it is, will constitute an unreimbursed medical expense for this VA pension benefit. If you are in something less than that, an assisted living facility, a memory care facility, something like that, then the doctor has to certify that you need to be there to receive the treatment that you need. And if you can position the claim appropriately using those guidelines, then the cost of the facility can also be considered an unreimbursed medical expense. And that's a really big one, because sometimes what we see is we see people that are kind of on the gray area, if you will, between needing no help and needing a lot of help. And so they're in an assisted living facility, and if they're getting the right kind of care provided in the right way and the doctor certifies it, then we can have the VA consider the entire cost, room and board, for that facility as an unreimbursed medical expense. So it's a really great way to maximize the pension that's payable to the veteran or the spouse. In-home care is the same thing. The cost of help with ADLs for sure and instrumental activities of daily living, if the doctor certifies their necessity, can be considered unreimbursed medical expenses. And this care, it's important to note, it doesn't have to be provided by a paid in-home caregiver. It can be provided by family members that are providing that care in home. We see this fairly commonly in situations where the veteran's spouse is the one that's providing the care for the veteran in the home. And so in those circumstances, we can file paperwork with the VA that quantifies the value of the service that that spouse is providing and count that as an unreimbursed medical expense. There's a little bit more to it. It's a little bit more complicated than that, but that's the basic thrust of it. So just know that even if there's a family member providing in-home care, that can still qualify potentially as an unreimbursed medical expense. Medicare premiums and long-term care insurance premiums can also be a deduction. Parts A, B, and D, and long-term care insurance premiums can be deducted. Prescribed medications, medical supplies, equipment, food, vitamins, and supplements, even if they're prescribed, can be covered as an unreimbursed medical expense. Again, remember, they have to be recurring. So, we see diabetics from time to time that have, insulin dependency. They have insulin supplies. Those kinds of things can be considered an unreimbursed medical expense because they do recur. If you have, this is a little bit less common, durable medical equipment a lot of times isn't covered because it's not recurring. But if there is a recurring element to it, then they can be considered unreimbursed medical expenses. And one that sometimes people forget about is like, we've had veterans or surviving spouses that have been, for instance, in an assisted living facility, and they are Ubering to see their doctor or to get test run or whatever it is. And so that transportation cost to transport them to healthcare providers can also be considered an unreimbursed medical expense. And I won't dive into it at this point, but I have kind of an ironic story about my daughter having gotten run into by an Uber that was actually transporting a patient to dialysis. So weird things happen, but you can cover those costs for the senior if that is applicable. So I'm giving you a lot of information. Please chime in the chat. It looks like Rhonda is doing a great job of answering questions as we go here. So thank you, Rhonda, for that. But if you do have questions, throw them in the Q&A box or the chat box, and one way or the other, we'll try to get to all of these. But I want to pause real quickly and walk through in a specific example how this IVAP calculation works before we move on to the other part of the net worth. So let's use an example here. Doris and John are married. John is a World War II vet, and he gets $1,800 a month in income. Doris gets $1,200 a month in income. So collectively, we're going to run through a couple of questions here about IVAP. So what is their gross income that the VA looks at? Well, obviously $3,000 because it looks at the household income. Both John and Doris's income count. So together, that's $3,000. Now, Doris and John live in an assisted living community that provides John with help with bathing and dressing. The cost of them being in that assisted living community is $3,500. In that scenario, what would their IVAP be? Well, we step through it. We look at their gross income. We compare that and subtract the authorized deductions from that. And we were going to assume that we have the paperwork that would qualify the assisted living community as an unreimbursed medical expense. So we get to deduct the entire cost of the facility. So we take the $3,500 away from the $3,000, and you can see this is a circumstance where they actually have a negative IVAP number. Their income for VA purposes is lower than zero, so they get the full amount of the benefit. How much would he get? Well, he's going to get $22.96, which is the maximum amount of the benefit, because he is a married veteran with aid and attendance level care, because again, he needs help with bathing and dressing, which are ADLs. So he's going, this is the where you want to be. This is the gold standard. He's going to get every dollar he's entitled to help him pay and help Doris pay for the assisted living community. So if instead the assisted living community cost was $2,500, how much pension benefit would John get if he qualifies? Well, again, we do the math, the gross income less the $2,500 in unreimbursed medical expenses. And we're assuming that there aren't other unreimbursed medical expenses. There may well be, but for simplicity's sake, we're just looking at the ALF costs. So $3,000 less $2,500, that leaves $500. That is positive income for VA purposes. So as I mentioned, you're going to have a dollar for dollar reduction in the amount of the benefit, the maximum being $22.96. There is a $500 deduction because of positive IVAP. So that leaves you with $17.96 as the benefit that he would then be eligible to receive each month. Okay, we're going kind of fast here because we are limited in time, and I do want to be sure and allow for lots of questions if we have them. So I'm going to move on to the asset piece. Again, we said net worth is measured by 1 year's worth of income and the value of the assets. So we've looked at how the income works. Now let's look at how the assets work. What they do, the VA does, when they look at the asset value is they look at the fair market value of all property owned by either spouse, with some important exceptions. One of the most important of those is real property. The assets the equity value of a single family residence does not include the residence that you live in, including the lot that the house is on, up to 2 acres. So that's a really important one because, as we all know, most of our veterans and their surviving spouses are going to own a home. Sometimes they don't, but that is a very common asset. And it's a very valuable asset in a lot of cases, because many of our veterans and surviving spouses live in the home that they've lived in forever, and they've paid off their mortgage, and all of the value of that house is equity. And so that can be a very substantial asset for them that the VA does not count, and it doesn't matter how much equity. Unlike Medicaid, where there's a cap on the equity value, there is no cap on the value for a VA claim. So you could literally live in $1 million house, and the VA is not going to count the equity value of that house in this net worth calculation. And it's important to remember that that remains true even in a couple of transitional type situations. So if the veteran moves out of the home and moves into a nursing home but maintains the house, the value of that house remains excluded even though they don't live there. Even if they're in a nursing home or a care facility, or they move in with a family member for health or custodial care. In all of those circumstances, the value of that house is not going to count as a resource from the VA's perspective, which is a wonderful thing. That didn't always used to be the case. They changed the rules about 3 years ago, 3.5 years ago, that made that clear. And it's a very, very beneficial change for veterans and their families. And the last thing that I'll highlight here is that remains true even if you rent the house. So in this scenario, veteran moves out, goes in to live with a family member for health and custodial care. They keep the house, they rent out the house. The value of that house still doesn't count as an asset. Now, the income that that house generates counts against the veteran or the surviving spouse, but the value of the house itself does not. Another big one that we see a lot is personal property. We do not include in the calculation of net worth the value of personal effects, and they have a fancy definition, but basically it's the stuff in your house doesn't count. So couches and TVs and appliances, there are certain probable limitations to that. There is no language of limitation, but let's say, for example, you have a Monet hanging on your wall. The VA is probably not going to consider that personal property. They're going to consider that a valuable art piece, and they're not going to consider it personal property, even though legally it really is. The VA is probably going to take the position that that's not suitable to and consistent with a reasonable mode of life. Most of us don't have Monets hanging on our walls, so the VA is going to count that most likely as a resource. But everything else that's has a reasonable value and is reasonably necessary to live, the VA doesn't care about the value of those items. So we've got the income piece a little bit under our belt. We've got the assets piece a little bit under our belt. Let's put the two together and let's go through a net worth calculation example. So we're going to still use Doris and John. We're going to add their assets into the mix now. They have combined assets of $150,000 and income for VA purposes of -$500 a month. So this is that first example where their income was $3,000 and their ALF costs were $3,500. Therefore a negative net worth, or sorry, a negative IVAP. In this scenario, what would their net worth be? So again, the $150,000 of asset value is going to be their net worth, because negative income for VA purposes does not reduce net worth. So you don't get the benefit of negative IVAP and then offset your assets with that negative net worth. It's capped at zero. It's then just the value of your assets. So here the net worth in this example is $150,000. Let's change the facts a little bit to say that if their income for VA purposes increased to $1,200 a month, what does that do to their net worth calculation? Well, you do the math and you look at their asset value. We know that hasn't changed, but now we have $14,400 of annual 1 year's income for VA purposes to add to the asset value. Excuse me. So now instead of having net worth of $150,000, they have net worth of $164,400. So the question obviously then becomes, do they qualify for benefits? Well, not really, because we have some work to do. Right now, they're over-resourced. They have net worth that's in excess of the maximum allowable amount. And the amount of that is what we need to deal with. So what do they have to do? What would we have to help them accomplish in order to have them qualify for the benefit? Well, we have to get rid of those excess assets. We call those in the VA parlance covered assets. So anything above the maximum is what the VA considers a covered asset. So we would have to come up with a plan to deal with the $33,627, and I'm not sure my math is working out there correctly. I may have a little typo there, but basically the 164, the excess over 130 is what we have to deal with. So how much of a penalty is that going to create? Well, I guess my math is right, actually. How much of a penalty is that going to create? Well, it's going to create about a 14-month penalty. And the way that we calculate that is, and the way the VA calculates that, is they take the total amount of covered assets, not anything under 130, but anything over 130, and they divide that by the maximum annual pension rate. And of course, as we keep saying, that's $22.96 for a married veteran with a spouse. So even if it's a surviving spouse and they would otherwise qualify for a lower benefit, they figure out the penalty based on the maximum benefit. So actually, this is one of those scenarios where surviving spouses or single individuals typically get a little bit more of a break in the calculation of this penalty. So this would result in a 14-month penalty because they do round down the number. And basically what that means is when you file the application for benefits and you become approved, but there is a penalty because there is a transfer of assets in excess of the maximum, then the VA simply does not start paying the benefit until that penalty period goes away. So bonus question, I used to, when we did those things in person, I used to take candy of some sort and toss it out into the audience if somebody get a bonus question right. So I'm sorry I can't do that today, but just in your head, if you get the answer to this question right, then you're smart and you should get candy at some point. But how much of a benefit would John get? Well, we're going to do the math. The maximum annual pension rate less the income for VA purposes. So that's the $22.96, which is the maximum benefit, less the $1,200 a month that he gets in his, or that he has for his income for VA purposes. That will get subtracted from the maximum benefit. So instead of getting the maximum benefit, because he has this penalty, and because he has, because he has income for VA purposes as well, zero, he's going to get $10.96 a month. So a lot of math. I went to law school, so I didn't have to do math, but fortunately this is fairly basic. So you just have to kind of step through the calculation to see where you end up. And these are the kinds of things that when you work with someone who helps you get qualified for benefits, these are the kinds of things that we help you work through. So why are we concerned about transfers of assets? The reason is that because, again, as of about 3.5 years ago, when the VA changed its rules substantially, they instituted for the first time a look-back period and associated transfer penalties. Well, what am I talking about? The look-back period is 36 months before the date of the application. So if I file my application effective May the 1st of this year, the VA is going to ask me in that application, have you transferred for less than fair market value any assets in the last 3 years? So 36 months before, so all the way back to, April of 2018, have you transferred any assets? And one thing that's important to note, and we're kind of aging out of this to a certain extent, but I keep saying that the rules changed in 18, and it's significant here primarily because if you transferred assets before the effective date of this change, which was October 18th of 18, then those transfers of assets do not count. The VA does not look at asset transfers that predate October the 18th of 2018. So that can be significant. So for example, if 5 years ago, grandma or grandpa gave away a bunch of assets to kids or grandkids or charity or whoever it was, as long as it's before October of 18, then it's not going to hurt them from a VA standpoint. It might from a Medicaid standpoint, but again, that's a different discussion. What transfers are subject to penalty? the VA considers a transfer that's penalizable as any transfer of property for less than fair market value. And this includes transfers of assets to a trust and also to purchases of annuities. And I'll pause real quick to highlight this. The VA at the time of the rules change was concerned about veterans and their families that were being taken advantage of by scam artists. There were people out there that were putting together these programs and slamming people into trusts and slamming people into annuities that shouldn't have been put there. And they were creating huge issues, not to mention the fact that veterans and their families were spending thousands of dollars on products and fees that were nothing more than a scam. The VA was very concerned about that, and so they basically, for certain types of things, they just said, no more. We're going to penalize this if you do it. There's ways out of that if they were defrauded, but we have to be careful about what we do with trusts and annuities at this point. Remember that these transfers only apply to transfers of covered assets. Covered assets are limited to those amounts that are above the net worth limit. So anything above 130 basically is a covered asset. And so if I have $150,000 of assets, kind of going back to what we saw before, and I transfer $15,000 of that, all $15,000 is going to be penalizable. But if I transfer $50,000 of that, only $20,000 is going to be penalizable because the other $30,000 is not a transfer of covered assets. Another significant, and I probably should put this in bigger type than I have it because it's really important. The transfer penalties do not apply to transfers of already exempt assets. And as you might imagine, the biggest one that we've talked about is the transfer of a home. So for example, if a veteran transfers the ownership of their home to a family member, to a trust, an irrevocable trust that they create, the value of that house is not going to be a penalizable transfer because the house is already exempt. The transfer of that exempt asset is not penalizable. And that can be a very important planning tool for veterans to preserve their assets in light of the VA application. Now, again, I keep referring back to Medicaid partially for this reason. When we do eligibility planning and consulting with veterans, we always want to be mindful of how is what we're doing now potentially going to affect what we have to do later as care needs increase. So if we foresee a circumstance where the veteran or the spouse might need Medicaid down the road, then we want to be careful about the kind of VA planning that we do because that can have an impact on the planning down the road. But this can be a very powerful tool to shield from the VA's consideration the value of a house even when we transfer it into a trust. And that remains a very powerful tool that we have in our tool belt to help with eligibility planning. How long is the penalty period? Well, they take the total value of the covered assets, kind of like what we saw just a moment ago with Doris and John, and they divide that by 2296, which is the maximum annual pension rate, and then they round down. So as we saw, that calculation for Doris and John ended up being 14 months. Now, the penalty period is a maximum of 60 months. So even if you have transfers of $1 million of assets, it's going to result in a huge long penalty, but it can only be a penalty up to 60 months regardless of what the calculation yields because they cap it at 60 months. And let me pause on the 60-month issue. That raises an interesting issue when you do have asset transfers, the value of which create a very long penalty. Well, how do we handle that? Well, we don't even file the application for the veteran until the 37th month. Because remember, the look back period is only 36 months, whereas the transfer maximum is 60 months. So if you have a very long transfer penalty that is more than 36 months, then the solution is we just wait till the 37th month and file the application, because then we don't even have to worry about it because the look back period's expired. We don't even have to deal with the 60-month maximum. When does the penalty period start? Well, the penalty period starts the first day of the month following the date of the last transfer. So if a veteran transfers assets in April and then files an application, the date of the transfer penalty period, if there is one, will start on May the 1st. So the first day of the month following the date of the last transfer. Sometimes this can become important when you have transfers that have been done over time. They're not going to look at each one and start an individual clock for each one. They're going to wait until the last one and then start the clock on the first day of the month following that last transfer. And it's important to remember that the clock starts running when the transfer is made, not when the application's filed. Again, Medicaid is a little bit different. They run transfer penalties and transfer periods from the date of the application. The relative date difference is what applies. With the VA, it's when did you make the transfer? You figure out when the last transfer was, first day of the month after that, that's when the penalty period starts. Well, we've covered a lot. I wanted to leave you with one thing that used to be more significant than it is now. Hopefully it will become more so in the future. There is a process when you file the application, you get all your paperwork together, you send it into the VA, and then the VA starts to consider it. There is a process called the fully developed claim process that can and has historically allowed for faster decision-making from the VA. And what happens is normally that process was taking anywhere from 6 to 12 months. Now that process can be even longer than that because although we're emerging from the pandemic, COVID has still sequestered the VA workers in their homes. They're processing these claims from their homes or home offices. So the process that was 6 to 12 months normally is now even longer than that. There are some exceptions. We sometimes get them done quicker, but that's typically what we tell folks. The fully developed claims process is a process where you submit all of the records at the time of the application that you think the VA might ever need. And you certify that to the VA and say, this is all you should need, please process in this fully developed claims process. And what happens is the VA then reviews and processes that claim, again, theoretically, more quickly. Used to be the standard response time in the FDCP was about 3 months. That's obviously increased at this point because of COVID. We hope that that will come back. But this process still remains. So when we get back a little bit more back to normal with processing times and processing processes, if you will, then hopefully this fully developed claims process will once again become a benefit. And as a general rule, we want to submit everything that we think the VA is going to need, regardless of which process it's going to go through, because one of the things that creates delay in benefits more than anything else is the back and forth with the VA. So if you send them something, what you think is everything, and then they send you what we call a development letter back that asks you for additional information, then we have to submit that, and then they have to process it again, and then they got to figure out if they need anything else. So it's this back and forth that's a time killer. We want to try to eliminate that as much as we can. So we want our clients to be submitting everything that needs to be considered at one time so that we minimize this development process. So we're coming up on the hour, so I want to wrap this up, and I want to give you a couple of closing thoughts. And the first is, why would you need a lawyer to help with this? Because you actually don't have to have one. It's not required. You can process one of these claims yourself. You can work through one of the many VSOs or veteran service organizations that are out there that do wonderful work in helping veterans and their families navigate this process and go through the application process. So if that's the case, why would you want to hire a lawyer? Well, the fact that we've been spending an hour just touching the surface of a lot of these things lets you know that it can be a confusing and complicated process. There are legal strategies that can help you qualify and qualify faster that we as lawyers can avail ourselves of and use for our clients that non-lawyers may not be able to do. We also address other needs that arise in the context of these conversations with families. So for example, if we meet a veteran or a surviving spouse that doesn't have a will, or powers of attorney or medical directives, we can help with that because we can put those documents together as we're dealing with the veteran and their family if they need it. And I would submit to you that if you have a family that doesn't have those, they need to have them. Everybody needs to have them. It's not a matter of when, it's not a matter of if you're going to need them. It's a matter of when. You're going to need a will because everybody dies, but you're also more likely to need, before death, a power of attorney and a medical directive. If you don't have those, that's something that an attorney can help with. These documents need to be updated if they're more than 3 to 5 years old, and if they were done in a state other than the state that the veteran or spouse is residing in, then they need to be updated, and an attorney can help with that. This is another big one. Why do I need an attorney? Because hopefully the attorney is going to be not going to be someone that's going to scam you. There are organizations out there that thrive on preying on veterans and their families. That's how they make their money. And you are more likely to avoid that if you deal with an accredited veterans attorney. So I would encourage you to consult with someone that you trust, consult with an attorney that's accredited by the VA, and you can find those in your state by just getting on the VA's website and searching for their database of accredited attorneys. You can plug in where you are and it'll give you a list of accredited attorneys in that area. So I would encourage you guys to do that. So with that, we're at the top of the hour. Here's our contact information. If we can ever answer any questions for anyone, you are free to reach out to us and ask us. We do free consultations if anybody ever needs that, but mostly we just want you to have this information. You will be getting a copy of this PowerPoint emailed to you so that you'll have that information. If that stimulates questions or concerns, we would love for you to reach out, and we will be happy to talk with you about any of those issues. So with that, I will turn it over to some of my colleagues here to let us know if we have any questions that we need to answer that haven't been so far.
You don't want to look at the questions. Just so you know, if you should have received the download for the slides this morning with a reminder email for the webinar. Also, I have put it twice into the chat, but I will also send that link out in the follow-up email with the CEU information as well. In addition to that, I know a few people have asked. This is being recorded, and everyone who registered will receive a link to the recording, but that will be in a second follow-up email in a few days. It takes a little while to get that recording processed and get it up on the internet. So.
Okay, so I've got some of the questions pulled up that we have not yet gotten answered. Rhonda, again, thank you for being my co-pilot here and answering these questions. And if you have, as we go through here, Rhonda, if you have anything to add on any of these, please feel free to chime in because you have tons of experience with this as well. So the first one that I see here that doesn't have an answer yet is an individual said that they had applied for benefits with the VA because of asthma on 3 different occasions, and there was a denial of benefits and so forth. This is what we call a service-connected pension claim. This is a situation where you would need to document to the VA's satisfaction not only the condition that you have, but that condition was caused by or made worse by an injury that you suffered or your experience in the service. So asthma, that can come from lots of different things. You mentioned airplane fumes. That can certainly be one. Agent Orange sometimes is a big one that we see. It really comes down to making sure that you have all the documentation that you would need to show the connection between your asthma and the service that you had. And so if you haven't consulted with a veteran service organization officer or an attorney, accredited attorney, to talk about whether or not you had sufficient evidence of that, I would encourage you to do that. We deal with those kinds of claims very sparingly. We focus more on the non-service connected pension claims. But if you have a need, we can certainly get you to the right spot. So I hope that answered your question.
Yeah.
Yes.
If the veteran is married and healthy, but their spouse is disabled and needing help, can they claim an aid in attendance for care for the disabled spouse?
Excellent question. Thank you, Carol, for asking that question. The spouse's medical condition is relevant, but not for the reason that you suggest. When the VA awards benefits, it is benefits that are payable to the veteran, and it's the veteran's disability that is applicable, right? So if we have a healthy veteran and a sick spouse, a healthy veteran is going to be what decides what level of that benefit they're going to get. Now, if they're over 65 and their service is in the right place, that healthy veteran can very well get a base pension amount. But they're not going to get aid in attendance if their spouse is disabled, because again, it's the veteran's health that matters. Now, the spouse's medical expenses, however, can impact that calculation. So the spouse's medical expenses that are recurring can reduce the household income for VA purposes. So the spouse is relevant, but not for how much benefit is the maximum allowable benefit, but in how much of that maximum allowable benefit the veteran is going to receive because of the impact of her medical expenses or his medical expenses. So excellent question, Carol. Thank you for asking that. Anne asked, what about diapers or depends? Is that unreimbursable? If it is necessary, I don't know that you can get a prescription for that. I don't know that you have to have one, but if you can demonstrate it, it's a recurring medical expense that, if you have incontinence issues, you really don't have a choice. So I would include it and then let the VA decide. They ultimately decide whether it's reimbursable or not. I would definitely include it on the application. The worst thing that can happen is that they don't count that as a portion of the unreimbursed expense.
I'm going to make sure I reiterate what Regina's put on here. Every county in Texas has a Veterans Service Office and a person that can help at that office. I want you to make sure you should be familiar with that service office number, but every county in Texas has a Veterans Service Officer.
And there are also umbrella organizations, Marty. Thank you for making that point. There is, for example, in North Texas, we have the Veterans Center of North Texas. They serve more than one county, and they are a wonderful resource for veterans and their families in getting understanding of the various benefits that are out there. And let's not forget, the Veterans Association has a myriad of benefits for veterans. These only scratch the surface. There's mortgage assistance, there's healthcare assistance, there's a veterans nursing home. There are all kinds of benefits. There's burial assistance. There's all kinds of things that the VA does for the veterans. In my opinion, not enough. Rhonda may agree with that, but she's a veteran as well. But the veteran service organizations can be a great guide to navigate the maze of all of the things that the VA has to offer. So I would highly encourage any of you to reach out to them if you have questions, if you want to start with them to get information. They've got pamphlets. I mean, they are a wonderful resource. So each county has their own office, but then there are other organizations that are VSOs that deal with more than one county. So an excellent resource. One person asked, do 401ks or other retirement accounts qualify as an asset, or are they exempt? Unfortunately, for purposes of the VA benefit analysis, IRAs and 401ks and other type of retirement accounts are countable. They are not exempt. If you start looking at Medicaid in Texas, for example, depending on the kind of asset it is, they could be exempt. But for VA benefit purposes, they are included in the asset value calculation. Carol, another question asks if a certified attorney helps a client file for pension benefits, what does the attorney charge for the services? Another great, Carol, it's like you're a plant or something. You're asking really good questions. So thank you for that. The way that process works is that the VA does not allow anyone, attorney or otherwise, to charge for the preparation of an application. That's a given. If what you're doing is helping someone apply, you cannot charge them to do that. There are things that need to be done in advance of an application for benefits that don't involve the completion of an application. So for example, If we utilize one of the tools that we sometimes use to help with eligibility as part of the pre-application consulting process, there would be a fee for that depending on what we need to do. But the application itself and the processing of that application until the point where they get denied and you're now doing an appeal, the Veterans Administration does not allow attorneys or anyone else to charge for those services. So the answer is, if the help that you're talking about is application help and processing the application, there is no charge for that. Let's see. So I'm trying to scroll through these real quick here.
Sharon, I saw that you raised your hand, but if you could put whatever comment or question you have. Oh, I guess you've taken it down. I apologize. I didn't know if you had a comment or a question. If you put that in the chat, please.
Linda asks, what is the maximum benefits for a surviving spouse who has been certified by a doctor for aid in attendance and only has Social Security income and is currently in an assisted living facility, no assets? Again, we would have to work through the calculation, Linda, to figure out exactly how it's going to work. But it sounds like the way it's going to work is that her Social Security income is going to be her only income. And if we can qualify the ALF costs as unreimbursed medical expenses, then that will certainly zero out, most likely, the Social Security income so that the income for VA purposes is zero or less. And if there are no assets, then in that scenario, there shouldn't be any issue from a financial standpoint with eligibility. And she's going to get the maximum benefit as a surviving spouse. So let me go back real quick, and I'm sorry to jump around here, but I do want to illustrate the point here. So let me hop back through my slides. This is kind of a inefficient way to do it, but that's what we'll do. So what's going to happen is when they evaluate her claim, because if she needs help with 2 or more of her ADLs, then she's going to qualify as a surviving spouse that is eligible for the surviving spouse benefit on an ADL level. So hopefully you can see this at the very bottom on our status, the surviving spouse, if she qualifies for the aid and attendance level of benefit, because she has most likely negative income for VA purposes, she's going to get almost $15,000 a year in pension benefit. And even if she doesn't need help with 2 or more ADLs, she's potentially going to get the $779. But remember that the unreimbursed medical expenses, the cost of that facility only qualifies as that if the doctor certifies that she needs care provided for that, for her in that facility. So it's sometimes a catch-22. You may not have the ADLs and you may need only the basic pension, but because you don't have ADLs, you may not also have the unreimbursed medical expense of the facility to net against the Social Security income. So I think there's probably in this scenario room for a benefit. It's more from my standpoint a matter of what that benefit might well be, because you'd have to run the numbers and do the math to make that determination.
Jeff,
yes,
can a common law spouse receive benefits?
Wow, you guys are asking really good questions.
Yeah, I got this one, Jeff. I think I answered one of those maybe on the Q&A. It is possible for a common law spouse to receive benefits. There are a couple of extra forms and extra documentation you have to submit in order to really prove that that's the case. And it's tied to the state law and common law marriage where that person lives. In the past couple of years, we have had one of those that we were successfully able to get approved as a common law surviving spouse.
What she said.
Glad I could help. I've been typing furiously and I'm not keeping up.
No, you're doing great. Rhonda is a wonderful resource, and she's very knowledgeable as well. So thank you for that. It doesn't look like I have any more questions in the Q&A box. And I don't know, Rhonda, if there's any outstanding things that need to be addressed from the chat, but if there's anything else that we can address, I'm happy to do it because we have a little bit more time left.
Well, you're looking at that. Can we go to the last slide? I want to make sure before we that I don't forget this.
And here is one more question, by the way.
Yeah, that's good. That's good.
If the veteran is caring for a disabled adult child, would the adult child's medical expenses be included?
All right, I got distracted. If the veteran, say that one more time.
If the veteran is caring for a disabled adult child, would the adult child's medical expenses be included?
Rhonda, I'm gonna answer it, and then you chime in if you have a different thought or an additional thought. If that child is part of the household, the way the VA defines it, then yes, I think that child's adult child's expenses can be considered as part of the income for VA purposes calculation. Do you agree, Rhonda?
Sorry, I had myself muted. Yes.
Okay.
Okay, and does the free consultation include an evaluation and determination if the veteran can qualify for more than they are receiving, or inform them that they are at their maximum benefits?
Yeah, whenever we consult with someone, we're going to look at the kind of the complete picture, and we're going to give you an understanding of, you know, if you're qualified now, if there's something that needs to be done to get you qualified, if there's something that can be done to get you more than you're already receiving. We had some situations where, for example, we have a service-connected claim that is, you know, maybe it's a 20% disability, and they're getting a couple $100 a month. And now their health has changed, not because of that disability, but because they're just getting older and they need more help. Now, for example, they need help with 2 or more ADLs. There is, on the service-connected side, there is an add-on for aid and attendance that can apply. But in that scenario, they may well get more money from the non-service-connected pension benefit because of their health that doesn't have anything to do with the service. So yes, we're going to look at all of the circumstances, and we're going to make determinations about you know, where you are and where you can be based on the information that we're seeing. And thank you, Marty, because I was having trouble figuring out how to get my screen back on.
No. I'm sorry. I didn't get this, but go ahead. Is there another question? I just want to.
Yeah, there's one more, and I think I know the answer, but I'm not allowed to answer. So my mother was enlisted 7/2 of 75. So she was outside of wartime. She is disabled with Alzheimer's and needing full ADL with a 24-hour caregiver at home. Does she qualify for anything from the VA?
That one I typed an answer, and I don't think
You must have answered her privately then. Okay, because I didn't.
Oh, okay. I didn't mean to, but if they didn't serve in the war times, they're not going to be eligible for aid and attendance benefits. But it's still worthwhile maybe to have a consultation about it, because depending on other criteria, Medicaid might become an option for somebody like that. So it's definitely worth looking into.
Well, and the other thing that I'll mention is that from time to time, I will run into situations where the service period either starts at the very end. I'm sorry, the service either starts at the very end of the service period or ends at the very beginning of a service period. And it can literally be a matter of days. And remember that there has to be a total of at least 90 days of service, but only one of those days has to be during the relevant service period. And so in those very close cases, it can be important. I mean, literally a day can make all the difference. And so what I always encourage people to do is if you think you might be eligible, you want to have a copy of the DD-214 document. That is a document that every veteran gets upon discharge from their active duty service. And it gives a lot of information about the length of the service, the character of the service, whether it was active or reserves. I mean, it gives the information that you would need to make the determination on eligibility. And it's going to be a document that the VA is going to require to process the claim. So if you are considering this kind of a benefit and you don't already have the DD-214, I would encourage you as soon as possible to reach out to the VA and ask for it, because it's going to be necessary. And right now, again, because of all of the pandemic issues, it is taking them much longer to get those documents than it has historically.
One more question just came in. Do veterans who have served, no, there's two more questions in. If both husband and wife are veterans, would they be looked at as one household, or could they double dip?
Rhonda, you want to take that one? You're muted.
Rhonda, you're on mute, Rhonda.
No, Jeff, go ahead. I'm sorry, I was typing and I didn't hear it all.
No worries. So the VA is always going to consider the resources of both spouses when they make their determinations. So even if there is, if there's one veteran and non-veteran spouse, their resources are still going to be collectively counted. So in terms of the collective counting of resources, that's always going to happen. But you can be eligible, unless I'm missing something that I'm not remembering correctly, Rhonda. Each veteran can be entitled to their own pension benefit. So it's I won't call it double dipping, because you're really not. Your benefit is as a result of your service to this country, and you're not double dipping. You're getting what the Veterans Administration is entitling you to receive because of your service for our country.
There is, when you have two married veterans, it's so rare that it happens, but there is a higher maximum that they can get as two married veterans, which is higher, of course, than just the one married veteran. I don't have the number right in front of me, but I can certainly find it. If the person who asked the question would like to email, I'll be happy to look that up and make sure they get an answer on the amount.
All right, last question that I see. Do veterans who have served in more recent wars, i.e. obviously the Gulf War, qualify for a pension if they have a disability, but they're younger than 65?
They can, yes. As I mentioned, the Gulf War service period has a start date, but it doesn't have an end date at this point. Congress has not made the determination that service period has concluded. So they're not common, but we have on occasion seen Gulf War veterans that it's more often for them a service-connected disability issue. And keep in mind that if you were to look and compare the rates of compensation between service-connected and non-service connected, the more disability that you have, the greater the service-connected benefit will end up being in dollar value than the non-service connected benefit. And that's especially true, again, because the service connected benefit is not means tested, right? So there is never a deduction of the amount that you're supposed to receive on a service connected pension because of how much income for VA purposes you have, because you don't have any for service connected claims. So it can be true that we never apply for a non-service connected benefit for those kinds of heavily disabled veterans because the benefit always ends up being richer on the service connected side than the non-service connected side. But yes, if you are a Gulf War veteran, so for example, let's say you're a Gulf War vet that you served and you weren't injured during your service, but now you've had a disabling accident or something happened on the job, and let's say, God forbid, you end up in a nursing home. There can be benefits available on the non-service connected side for those veterans if their service was in the right spot, even though they're under 65, because in that circumstance, they're in a nursing home. And that is one of the independent qualifications for a non-service connected pension benefit, is being in a nursing home. Or if they were blinded, let's say they got acid in their eyes at the workplace. Again, an example of how they could qualify for a non-service connected benefit, the full aid and attendance level benefit, even if they're under 65.
There's a few questions that have come up on the Q&A since we last looked at it. I just want to make sure you're able to look at those.
The last one in particular, the director of my mother's assisted living facility said after the application had been submitted to the VA and it shows she does not have the income to pay for her assisted living facility, they will increase the amount of the VA benefit to pay for the monthly payment of the assisted living facility. Is this true? She's already placed there.
Rhonda's typing an answer to that, but I'll pipe in with mine. I don't think that's true. I think that once the VA determines that the amount of her benefit is what it is, it's not going to, for the VA's perspective, it's not going to matter whether that's enough to pay for what she needs to pay for or not. They're just going to run the calculation based on her income. And if she gets a benefit, she gets a benefit. If she doesn't, she doesn't. And if she does, but it's not enough to pay the ALF, then that's a circumstance where, she would either have to private pay or have a long-term care policy. As Rhonda mentioned earlier, that could be a scenario where we might be looking at a Medicaid scenario rather than a VA scenario. And I didn't talk about this, but it's worth mentioning. Nobody's asked a question about it, but sometimes it comes up. The question sometimes comes up, if I get my surviving spouse, for example, qualified for a VA benefit, and then later she goes on Medicaid, how does that work? What ends up happening is that once you get, if you're on a VA benefit, once you get eligible for Medicaid, you have to notify the VA that you've now are on Medicaid. And what happens, or what's supposed to happen, is that VA then reduces the amount of the monthly benefit to $90 a month. So you continue to receive that benefit from the VA, but it's not, instead of $1,000, for example, you're only going to get $90 because you are now eligible for Medicaid. It's kind of this governmental coordination of benefits thing. It's still helpful to have it. I mean, $90 isn't a lot, but it's, as my grandmother used to say, better than a poke in the eye with a sharp stick. It's more than zero, so it's nice to have it. But be mindful that when you get on Medicaid, Medicaid is basically going to supplant the VA benefit in large degree.
Well, you all, that was incredible, as always. Really, thank you all so very much. I want to make sure we talk about next month, guardianship in Texas. I do want to make the point that it's the same day, but we're going to be doing a different time. Sorry about that for any inconvenience, but I'm traveling that day, and so we had to move it up an hour. So we're going to start at 9 a.m. And run till 10:30 as opposed to 10 to 11:30. So if you'll mark your calendar, I'll also be sending the flyer to this event out with a follow-up email for today's event. Did you all have anything else you want to add before we close?
Well, Marty asked a question of you, and that is, are they going to get these questions and the typed answers sent to them?
I probably not. The recording you'll have, it comes out, but it doesn't come out really in a format for me to send it out, and the Q&A doesn't come out at all. I don't know why the QA does not allow me to say save it. The chat does, but it comes out in a very odd format. So the short answer is I'm not going to be sending those out, but I will be sending you the link to the webinar and the link to the presenter slides out. In a few days, you'll get the link when we get that processed. But y'all, thank you so very much. Jeff,
hey, Marty, real quick, I'm sorry to interrupt you, but
no, you go right ahead.
We've got a couple more minutes here real quick.
Yeah.
Jean asked a question that I would like to answer.
Great.
Jean asked, if the veteran doesn't qualify for benefits because they're not in the wartime period, but they need help, what can they get? Rhonda mentioned that there are scenarios where, veterans unfortunately are not in that period. I think it's incredibly unfair, but I don't make the rules. If you are outside of that period, there are other resources. Remember when we looked at that slide about how you pay for care, that may well be a scenario where Medicaid can be a big help. There are obviously different rules that apply for Medicaid, and that's a subject of another conversation. But, that's a scenario where we would be happy to visit with you and let you know what other options might be available. Again, the VA has all kinds of other benefits as well. So that's potential, like for instance, there's a VA nursing home. There's VA healthcare. There's other things that could potentially help in this situation that this pension would ideally address, but may not.
Hey, Sheila, it may not fit this exact question, and you may remember the gentleman's name, but they do have kind of daycare centers where veterans with Alzheimer's or dementia can kind of go to day camp. So if
Right.
they're able to physically get there and interact some, and I believe that's at no cost, isn't it? If you remember his name, Sheila, it's not coming to me at the
I
moment.
do not, but I know who you're talking about. And yes, I am not, it is, wait a minute. The one in Richardson is called my friend's place or
Friend's Place, I think you're right. I think
friend's
that's-
place. Yes. And Marty, is that, I don't think it is a cost if you're a veteran.
I don't know that.
I shouldn't say that, Rhonda, because we have spoken there, and thank you for bringing that up. It's a wonderful place, a wonderful resource. But I don't remember that. I'll be honest with you, I don't remember.
I guess if it's something for any listeners that they're interested in, just send an email to Sheila or me, and I'm sure one of our memories will snap to it eventually.
And I will definitely check on it.
If I can
Yes.
remember.
You know, the other thing we've posted a couple of times, a statewide ADRC number, which I work not only with the Area Agency on Aging, but the ADRC in our counties is under the Area Agency on Aging. So I work with them as well. A couple of their people are on here, but I've put that number in the chat. That number is a statewide number, and they'll direct you to whatever county you're asking about, whoever the ADRC is for that, and they can surely help you identify those as well.
Thank you.
And somebody's put it in Friends Place in Richardson, McKinney, and Duncanville. Somebody put that in. That's great stuff. But once again, thank you all. It was exceptional. It was great stuff. And we look forward to seeing everybody next month for the guardianship in Texas. Sheila, thank you for all your help getting this together. And thank you for providing the CEUs. Incredibly valuable.
Absolutely. We're so happy to do this. And Marty, thank you for all of your contacts. And anytime we can be a resource, please don't hesitate to reach out to us. If we don't know the answer, we will certainly set about finding it for you.
Great. Hey, thank you all, and you all have a wonderful day.
Thanks, everybody. See you next time.
Bye.